Hi, this is Attorney Mike Grevin coming to you from Chicago. As usual, we've got a fun one today from Australia. I got it from Ben Bellin's channel. I'm going to put a link to that in the description below. It's a little something we're going to call Sovereign Citizen Court Fail number 18. Let's do it. From the secret headquarters of the Sovereign Citizen Patrol, initiating video production sequence. We are no longer playing. So let's get revved up. It's time for Law Talk with Mike.
Just have a seat.
Does this court obey the law, sir?
Just have a seat.
Does this court obey the law?
Have a seat.
Even just once?
Have a seat.
You know you're in trouble when he kicks it off by fake sitting. I mean, we're not even down to the basics. Can we just get in our positions and start talking?
Mr. Prosecutor, how many police witnesses?
4, Your Honour. There's Miss Quinn, a Gary French, Walker Vance, and informant Borwich.
So 2 police and 2 civilian. Now, Mr. Freeman.
Yes.
In terms of your defence of the matter, what do you say? How many witnesses do you have?
I'll run my case where I'm going to run it, sir. Magistrate Stella Stuttridge has already progressed this matter. On the 13th of December last year.
Mr. Freeman, I've asked you a question.
I don't understand the question, sir. What was that?
How many witnesses do you have?
Witnesses?
Yeah.
I don't need witnesses.
Okay.
I don't understand the question. He asked him how many witnesses he was going to have. A question you get before a hearing throughout the world. This happens to be Australia, but it certainly happens all the time. If you're setting up for a hearing, you want to know how many witnesses, because that. Then you can sort of start gauging how long this thing is going to take.
Actually, there's no witnesses. The purpose of this hearing is to determine how long the contested hearing will take.
Sir, it's not. That's not what Magistrate Stuttridge ruled, and I'm about to give you that information, and so far you suppress me.
Oh, my Lord. It's a pre-trial or pre-hearing, whatever it is, and they just want to know the number of witnesses and what we're going to do and set the proper time aside so that everyone can be ready to go. And, of course, he's talking about something another judge did, which is, irrelevant. This is the judge in charge of this process right now.
This
matter is listed for a contest mention. It's running as a contest mention.
Can I speak now, please, sir?
You have a question.
On the 13th of December last year, Magistrate Stella Stuttridge identified serious issues I raised, being a serious abuse of process in this matter, an order that was not made according to law, and many counts of fraud and perjury by the applicant.
There's also a serious abuse of vowels, but, he's Australian, so we'll give him a break.
So, I've implemented a voir dire that this case cannot proceed until these matters are dealt with. It was upheld by Magistrate Stella Stuttridge, who allocated a hearing, which is now a year later, this one, and she specifically said that Magistrate Cottrell is not to sit on the matter because he was the one that caused the problem, that Magistrate Watkins cannot because he is in bias, and that you cannot either. And then the registrar, Sam out there at the front, told me 3 weeks ago that you're one of the magistrates that had recused yourself from this matter. And I'm very angry that the registrars couldn't get it right and went and allocated this hearing while you were sitting when it was supposed to be Magistrate David Farram, according to Magistrate Stella Stuttridge.
Oh, there's just so much to unpack here. First of all, I love it whenever he talks about his feelings. It's a soft set staple apparently across the world. I'm very angry. I don't care. Say something relevant to your position that makes sense. Let's not. We're not here to have therapy. Okay. Number one. Number two. He tells the judge that the judge has recused himself. Well, I'm sure the judge is familiar with whether or not he's recused himself in the case. He doesn't need to be informed by the defendant. My guess is he hasn't.
She also stated in the court, on the record, which you need to check, prosecutions are on notice that the hearing will be an application to strike the matter out, nothing else. She said it is booked in for an application to strike the matter out. She specifically told that to Prosecutor Stuart Pritchard. There has been a shocking delay in justice in the past year.
This is just interesting to me. Sorry, this might be a little inside baseball, but I practice here, and I've never heard the phrase "strike the matter out," and it's just kind of funny. Generally, if I was hearing competent people do this, I'd be like, "Oh, that's interesting. What does that mean?" But I've got a sovereign citizen, so I don't know if this is a used term in Australia or just nonsense that he's made up. We'll find out, maybe.
Waiting for my hearing. I've been back to court to try and get it heard sooner, which is a perversion of the course of justice, and I'm not ready to make any more concessions for people. I've been to court 15 times. You would have been the fifth magistrate, but as it's gone around in a circle, the fourth magistrate to sit on this case. This travesty of justice and unlawfulness by Loretta Quinn, by the police and by this court has continued for 2.5 years. Even during the deaths, my family deaths I had 2 weeks after my sister-in-law dropped dead in front of the 4 kids, you and Evans and
I'm sorry, I don't mean to sound cold-hearted. And I don't know what the underlying matter is here. But the drama, or my sister-in-law dropped dead in front of the 4 kids. Now, I don't wish that upon anybody, but it's not relevant to this case. It's purely manipulative, and it's hilarious. Not that she died, but his inappropriate use of it in this context.
Eliades, French and Quinn and their lawyers all got in here and colluded all day long and harassed me for a full day in August.
Did they even take time out for lunch? I'm wondering.
Then you adjourned it to November, and I was hounded and hammered again in the most sadistic way for a full day. And then I still didn't get the matter resolved because this court is still unable to resolve it according to law, which would only take 5 minutes. Now, the crimes that were committed by Loretta Quinn and Magistrate Cottrell took 17 minutes on the court record. It has now taken me 17 months to try and get the law simply upheld and get this matter reversed. And I can assure you, I am extremely angry and extremely determined, and I have no more concessions or grace left for anyone involved, and I'm ready to...
Okay, yeah, that's all pure emotion. I'm extremely angry. I have no more concessions. I don't know if he's given any concessions, but frankly, I doubt it. And I don't care, as a matter of law. Do you have something relevant to say to the proceedings or not?
Launch private prosecutions against anyone who breaks the law in the court today. Now, I have the laws that are being broken, sir.
Freeman.
I'm being cut off, yeah? Okay.
Magistrate Stutteridge has made no orders in this matter. The matter is listed for a contest meeting today.
So you're going to railroad me again, okay?
I have no evidence that what you say is incorrect. So...
Oh, that hurts. You're in the middle of exploring your feelings, and then the judge cuts you off and hits you with facts in the record.
In terms of not calling any witnesses, it would appear to be a factual argument.
Correct, sir.
I have evidence to give on the stand, sir.
Factual argument.
I have evidence to give up there to this court. That's my right.
Hey.
Oh, yes, it is today. It is my right to a fair hearing. 2.5 years. Well, this needs to go to the Supreme Court. Do not adjourn this case, sir. You will be perverting the course of justice, and I will prosecute you.
What's the matter for you? How long will this matter take, Mr. Prosecutor? I would imagine at least a day.
At least a day, Your Honour.
This court has constructive knowledge of perjury being committed. You'll be aiding and abetting that if you proceed. You'll be in breach of Justice Gaudron's rulings in the High Court, Nicholas versus the Queen, 1998, by proceeding in a matter that is an abusive process, where there are other serious matters raised which have been identified by a previous magistrate. Yeah. You cannot proceed in this matter by ruling of the High Court of Australia. If you're acting in criminal bias, the magistrate acting oppressively or when interested, I have a right to a fair hearing and I have a right to justice. If I do not get it, this proves that this is not a court of competent jurisdiction and you will be prosecuted, sir. For the Supreme Court and High Court Justices listening to this recording in the future, take note the Magistrate Dunn is not allowing me to have a fair hearing is obstructing justice and is in breach of the law.
Yeah, your position's been made clear. It's wrong, but we know what you think, okay? There's no confusion on that.
So I have an hour allocated for this hearing. I want to get up on that stand and give some evidence.
No, you're not.
Okay, well, you're perverting the course of justice. I've had enough of it. You're acting oppressively and when interested in breach of the Crimes Act.
You're available on the 5th of February?
No, sir, you have constructive knowledge of crimes committed in this court. You are now aiding and abetting them.
Are you available on the 5th of February?
Peter Dunn, I arrest you for aiding and abetting.
Don't forget to hit like. The boys would really appreciate it, unless you have something against Frankie and Ollie.
Okay.
I arrest you for acting oppressively and when interested and perverting the course of justice. You must stand down. You are now in my custody and under arrest. You are not free to leave.
Just my
Whoa, the judge is in his custody now. This is, wow.
For the Supreme and High Court Justices listening to this recording in future, take note that the magistrate is under arrest for serious crimes committed against me, as have been outlined in numerous hearings and this one. I have no choice but to make this arrest under Section 458 of the Crimes Act, which is my lawful right to do so. This case cannot proceed. Right, who's the highest ranking?
I just love that the only other two people on camera are having none of it. They're like, whatever, just keep going. No one's remotely impressed. It's beautiful.
Police officer, you?
That'd be me.
Right.
No.
So you're obliged.
No, I'm not.
Excuse me. You're obliged to
Excuse me
make
for a
the
moment.
arrest.
No, I'm not.
Excuse me,
A
Mr.
lawful
Freeman.
arrest has been made.
Mr. Freeman, just excuse
You
me for a
address
moment.
it, please.
5th of February at this court or at Juliet, at this court or at Myrtleford? Well, I need to know now whether it's Myrtleford or is it 5th of February Myrtleford Day? Okay, 5th of February at Myrtleford.
Mr. Doss, I arrest you as well for malfeasance of public office and refusing to do your duty.
The other thing that's interesting to me, and I can't tell, the audio is hard. I hope it comes through when I do this. But this was always the plan. The judge asked, who are your witnesses? How long do you think it's going to take? Prosecutor says, I think it's going to take a day, and I've got 4 witnesses. They weren't planning on proceeding with this today. Ever. They're setting it for trial because you want to get your witnesses there. So you want to set a date so you can send out notice and get people there and then proceed. So, you know, again, he's reading it as some grand conspiracy theory. No, this is the way trials are done, period.
And your other charges will be added to that. Okay? So for the court record, for the Supreme Court and High Court Justices listening to this recording, you're both under arrest. This matter has stopped. You are not free to leave. You are in my custody. If you leave, you will be escaping lawful custody and resisting arrest. That's the
I love this. He says he's going to arrest the judge and everybody in the courtroom, and of course everyone's ignoring it because it's silly. But when the prosecutor says I'm going to add charges, that's a problem. The prosecutor has the authority to do that, and the judge has the authority to rule on it, and he saw it. You know, so it's very interesting.
law under Section 458 of the Crimes Act, which I am entitled to enact
I think that's your
according to the circumstances.
That would be your interpretation of the law.
So what do you want, Brett? All right.
Well, no, but just because you say so, Mr. Freeman, doesn't mean it's right. 5th of February.
Please, then, Constable Sarah Williamson. It's now your role to arrest Mr. Dosser and Mr.
Time to go, Mr. Freeman. The matter's put in for a hearing.
It's done, Mr. Freeman. You're
Okay.
excused from
I'll collect my papers. Thank you very much.
good job.
Absolutely disgusting. Shameful. Now, the paper that you need, a document for the court, sir. I must leave here, according to law.
Well, if you leave it at the front counter, that'll be just...
Okay. Because you are under the Criminal Code Act, Section 83(4), because you are using force and intimidation to interfere with my Australian democratic and political right to have my case
Off you go, Mr. Freeman. Off you go.
I arrest you, sir, and
Time
I
to
arrest
leave.
you.
If you like.
Time to leave.
Time to leave. Grab your papers and off you go.
Oh, off you go. That's so charming. It's kind of old school, and it's just kind of, nah, you gotta go.
So all of you police in the courtroom and magistrate are arrested according to law. This will be taken up in the Supreme Court. I'm now under duress. I fear for my safety, given that there are four armed criminals.
Phone and all your bits and pieces.
Four armed criminals surrounding me in an intimidating manner. I'm under duress.
Off you go. Bye, Mr. Freeman.
Thank you for your time.
You'll be receiving your charge sheet summons.
Well, there you have it. That was just pure fun for a little crazy from down under. He arrests everyone in the court, of course. We've seen it tried before. You know, I don't know where they think this is going to lead. I mean, obviously, it's not going to work. He doesn't have the authority or force to execute that. Here at Law Talk, we answer all your legal questions and give detailed analysis of current events. Who am I kidding? We just mostly laugh at horrible court appearances. And occasionally you might learn something, but I promise I'll try to keep that to a minimum. Thanks for watching.